Pooja. So I think we had very interesting remarks by Dr. Saraf on the remakes and the inspiration and all of those aspects. And because you deal with these issues day in day out, what are your comments in terms of when you look at Copyright Act? Does it give you any guidance when you're looking at, say, remake rights or a franchise right or or something, somebody comes to you that this is only an inspiration, it is not a copyright infringement. How do you look at those aspects, both in terms of amendments required to the Copyright Act, number one, and second, if the Copyright Act is not giving you the answer, then in terms of deal making, how do you safeguard yourself?
So let me start by kind of looking at it from the perspective of operationally how we handle it. So when we look at copyright, all of us know that copyright only exists in the expression of an idea and not the idea itself. So there is no protection for merely an idea. So when we talk about inspiration, as long as it is an inspiration from a central idea encompassed in a film, which basically, if you look at 99% of the films produced in Bollywood, it would be revolving around 3 or 4 central themes, which is expressed in different ways. Like most of the films will have a hero, a heroine. There will be an issue which will be brought in by a villain, and then the hero basically overcomes all those things and rides off into the sunset with the heroine. That is basically all the 80s, 90s movies, right? So, but it is expressed in different ways. So, if you look at inspiration, it doesn't actually have a foundation in Copyright Act because it basically emanates from an idea. So as long as it is kept to inspiration, when people come to me and say that, okay, we have been inspired by this and we want to do something like this, I'll say, okay, it's absolutely fine. But we need to be sure that inspiration doesn't cross into the border of copying a part of that work and incorporating into this new work. Then that becomes an infringing work per se. So that is where we need to draw the line as far as inspiration is concerned. Now coming to adaptation. Adaptation basically remakes, dubbing, all those things comes into adaptation, the rights of adaptation, because adaptation is defined under the Copyright Act in a very straitjacket way. It only deals with change of format. If you look at the definition of adaptation, what do I mean by change of format? That is basically a literary work, basically a book being made into a dramatic work or being made into a cinematograph film. So that is where the 4 corners of adaptation resides in. So if you are looking at a remake, for example, you take the rights in a book and create a movie out of it, or you have a movie which is already produced in a different language to be remade in Hindi language. So this all comes in the 4 corners of adaptation. Apart from adaptation, the main play that happens in today's world are in prequels, sequels, and spin-offs. Where do these reside? If you look at Copyright Act, you will not find any place it resides in the Copyright Act, because Copyright Act deals with only adaptations and the copyright of a work. Now, if a work, let's say the 4 corners of a work, when I say 4 corners of a work, let's take the title of the movie, the characters which has been built in the movie, and the storyline of the movie. This storyline, these 3 elements, that forms the foundation of a new work, basically like a sequel or a prequel. Basically the the story moves backwards or forward. That's what happens in a sequel or prequel, right? So the foundation for the new work is actually an existing work. However, the new work has it is 99% new original work with that 1% which is the foundation of the work, which in media or entertainment parlance we call it derivative. So it's a derivative of the original work, but it is not the original work per se, and it is not an adaptation of the original work as well. Now there is no definition of derivative in the Copyright Act if you look at it. But if you look at US Copyright Act and all, it recognizes derivatives. So maybe it is time for our law also to look at derivatives and give it an existence apart from what we see in contracts today. Today, if you have to go and argue a case on derivatives, it's going to be a tall order, because you'll have to explain to the court what a sequel, prequel, and derivative is, and how it forms it finds its foundation in an already existing work. Now, we have been faced with very unique cases as well, wherein the adaptation and derivatives overlap with each other. Like we got a right, exclusive right, to remake a particular movie in Hindi language, and along with that, we also had the exclusive right to make sequels in Hindi language of that particular movie, which we have produced. Now, after a point of after maybe a couple of years, there was this sequel of the original movie, which was created by the original producer, and the remake of that sequel in Hindi language was given to a third party. Now, the question before law is whether that sequel, the remake of the sequel in the original language, transgress into the exclusive right that has been granted to us to create a sequel of the Hindi remake in Hindi language. So there are a lot of confusions that can arise out of this, if which can be avoided. I won't say that it can be avoided completely, but can be avoided to a certain extent if the word derivative and the derivative rights find some mention in the Copyright Act and find some kind of definition under the Copyright Act. Now comes to spin-off. Spin-off is again a completely different animal from all of the other things that we discussed: adaptation, sequels, and prequels. What is a spin-off? Spin-off basically depends on two things. Actually, basically depend on one thing. That's the character. Now, how a character, what is the rights in a character? How a character becomes a copyright is another interesting aspect of copyright. It can be built in two ways. One, through literally a character can be built, so then it becomes a literary work. For example, I'll give you an example of Dr. Watson from Sherlock Holmes. How it was only found in books, like before it was made into movie and all those things. It was made in books, created in books. So Watson has a limp, and that limp has a backstory. Watson is the aide to Sherlock Holmes. He's a medical practitioner. So this is the way his character has been built up. Now that character is capable of a spin-off. I mean, there can be a series only on Dr. Watson without Sherlock Holmes as well, because he is a central character in that particular this thing. A more precise way or more recent example would be if you have seen the series called Breaking Bad. There is a sleazy attorney there called Saul. So now we have a complete series called Better Call Saul, which is also running into many seasons. And in the original Breaking Bad, he was only one ancillary character, but he became so unique that the spin-off was possible. So this is the literal way of creating characters and spin-offs. Now let us come to the visual way. How visually a character becomes unique. So if you have a super hero movie where there is a all superhero. When I say superheroes, what is the first thing that comes to your mind? There is a cape, there is a costume, there is a mask. Correct? This is the first thing that comes into your mind. But it's not unique. All superheroes are in the same manner. I mean, almost 90% of the superheroes are like this. But the moment I say the costume is blue, the cape is red, and there is a distinct font, in a distinct font, S is written on the chest. Who is it then? It's Superman. Correct? So that is the way uniqueness has to be built into a character, to be able to protect that character. And that character, when I talk about visual representation, it falls into the domain of artistic works per se. The other one is in the literary works per se. So these are two ways you create uniqueness for the character. And only when there is a uniqueness to the character, a spin-off becomes possible. You can see it everywhere, like even the series called Motu Patlu that runs on our channels. There is an Inspector Chingam. Now the Inspector Chingam is a spin-off, and he has his own series. So everywhere, wherever the character is unique, you can build a spin-off on that. So this again is a completely different dimension to copyright. But all these things, I don't think will be able to, I don't think law can get into each of these things and protect everything. A lot of this has to be developed through interpretations, jurisprudence, and all those things as well. So
I think excellent examples, Anil, and I know that made me think what Dr. Saraf said and what you said. Even when we are talking about protection, right? One is what the law can do for you, and other things what can you do for yourself. Just to give an example, when you create, say, a character, when you're creating a film, and if you believe that this can create a spin-off or this can create, some other property, is it a good idea then to sort of do some kind of a write-up, because you need something tangible for copyright. So you create a write-up, say, of a literary work, publicize it to say that, so and so character, this is that background, and sort of create that activity around that character, so that when you create a spin-off or otherwise, there is some essence that is already developed, which can be created, rather used for protection of that character. Because we saw that, which was that film, Baby, and then you had this that Naam Shabnam or Shaban or someone, right? Yeah. Now in that film, that lady was just there.
Just there, yeah.
Right? But if somebody else had created, I'm just thinking aloud, somebody had created a film which is, a spy lady, right? Maybe look and feel similar. It would have been very difficult to protect that as a character. Right? But if they had created a written description of, little bit things around her in advance, maybe then, you have something to sort of hold on to, right? And I'm just thinking, because of the examples that you gave, absolutely, it's extremely important as to what you have created, the look and feel, as you said, right? The description of that look and feel, etc. So I think you mentioned about the Copyright Act in the US, and maybe that is something, and the reason I'm saying this again and again, because the one of the key takeaways from this workshop will be, recorded by the DPIIT team here. So you are recommending that can we look at something that is in the US Copyright Act insofar as insofar as derivative rights, and think whether there's something similar should be considered for India. I think that is one key takeaway, and the other one is, of course, everything can't be under law. So you need to sort of, do something additionally on your side to create that protection. So I'll come back to you, Anil, in a bit, but over to you, Pooja. Two things that were discussed, and since you represent the talent, and there was a conversation about, the screenwriters, or, when they create something, we spoke about recording, with the Screenwriters Association or otherwise. So what is your general advice when you look at the Copyright Act? And the second one is, when you are representing a talent, the point that Anil mentioned, a character. Now that character can be played by the same actor or can be played by another actor. So should the actor also have some IP attached? I'm using IP in a very, very broad sense, but attached to that character, so that whenever a film is made with that character, the writers, that particular performer should always be attached to that particular character, right? So I think these are some couple of questions I have. And also, when you look at the performer's right under the Copyright Act, and then there is a conversation about, or rather a particular provision about, when a commercial use is made of the performance, some royalty should be paid, right? So in the context of these rights that we are talking about, how do you look at that provision, if at all, whether that is relevant not, and how do you look at it?
Sure, thank you so much. I think a lot of points have been covered from a law perspective by Dr. Saraf and Anil. I think one point that I would like to bring, I'll probably break it up into your questions that you've asked. And when it comes to the first part of it, when it comes to just copyright law and writers at the SWA, what we always insist talent to do is every version of your screenplay that you're sharing with people, have it either registered with the SWA, so there is a trail, there is evidence for it. Or, as we all know, copyright, you don't really need a registration. You just need a proof on the date it was really created. So email it in a form to yourself, email it to a friend who you trust, and ensure confidentiality is maintained, of course. And keep paper trails of the scripts you have shared. A lot of times writers, especially younger writers, tend to share the script to multiple people across different production companies, right? So it's about just maintaining that database of who you have sent it, when you have sent it. And it's, as Dr. Saraf said very correctly, writers don't tend to have a team of lawyers protecting them. So it's only when they see a trailer, a lot of times they realize that, oh, I had sent this to them. And in fact, we had a situation where there was a litigation where one of the writers who had shared a screenplay to the production house, when they saw a trailer of a film on a platform, they sent a notice saying that, hey, you know what, this is copying my, it's very similar to my story. Luckily, the original writer who had actually created the work had a paper trail of her screenplay, which was registered with the SWA and shared with the producer before the date on which this was received by the production company. So it came, I think what you take away is just a paper trail in the form where on the date on which the work is created, that comes very helpful. And SWA does handle such kind of litigations and has a board and a panel basically which takes care of such litigations at their level. And it also goes back to Dr. Saraf's point on, the courts don't tend to watch the films together. In fact, Gigi, if you remember, one of the projects, one of the litigations we manage is where the SWA actually watched the original film and the film in which that they were claiming it was being infringed from, and they went scene by scene, understood. And one of the reasons they said it's not similar is because the look, the feel, what you take away in general from both the films was so different. The way it was created was so different that you could not call them to be, one is infringing the other. So we do see the SWA at several stages doing this kind of things, and one of the takeaways is always keep a paper trail to the material you've created. So that's, I think, the first point you've asked. The second was with respect to characters. And one of the examples which Mr. Anil gave is with respect to characters there are two parts of it, right? One is how, for example, a young Sheldon Cooper and a Big Bang Theory Sheldon, right? They are the same, and there is a personality characteristics to that person. It's a factor of not only how he is, but there are character traits to that person. And another example in our that I would drive slightly different is the Shah Rukh Khan and his classic, his hand waving move. Some of these things, and from a performer's right perspective, you would always see that are attached to the performer specifically because it comes from that performer. And if that is being used in a way which is getting monetized, they should somewhere get benefits out of it. Having said that, if they are just the same character and there are no specific character traits, it's, in my opinion, still slightly gray. Of course, there's a recollection value of the audience as a whole to see the same person from one place to the other, which helps monetization. But you also see a lot of remakes today where the same characters were there, like Vikram and Vetal and any of that. And you see different faces in different films for the same kind of characters, depending on the audience actually, and depending on the, basically the cinema it's created for, like Bollywood or Hollywood or any regional cinema. So you're seeing this in both the places where the same characters are played in remakes by other actors, and the same character in a spin-off is actually played by the same personality. Now in the West, there are rights, like in the US, there are rights given to such characters, such performers, and it's very clearly articulated as to monetary compensation for them. However, over here, you do not see that. There is, and somewhere it stems from the fact that these derivatives are actually not recognized under the law as spin-offs. So they do not get the monetary benefit of it. In fact, in the West, there are also, every time the content is screened in a different medium, they are getting paid a certain amount of royalty. If you see Friends being utilized on OTT channel versus a satellite, there is compensation going to the performers of it. So these are things which we don't currently have in our law, our rules, or there is no association which clarifies or does, defines this, which you see somewhere in the music, where if there is utilization of the music in different formats, they are getting a certain amount of compensation. So I would address that point and probably going back to even writers and commercial use from there, or directors. If there is an original IP that is created, or a character that is created, if I may put that way, you do tend to see again in the West that there is very clear monetary compensation requirement of providing credits for these kind of characters or this kind of screenplay or script, which you don't see in the law over here. So these are points we generally try incorporating in contracts. A lot of times when there is original IP created, there's a lot of commercial and legal conversation around derivatives, spin-offs, who gets compensated at what stage they get compensated, or if they get credit or not, because that's a very important part of the creating process for a creator. So what the law is not solving, and Mr. Alil can also agree, there are long run negotiations around this when it comes to protecting the writer, protecting the performer from a legal perspective in the contract. So
Yeah, I think so. What I'm understanding is, there are certain aspects. Ultimately, the industry or all the stakeholders in the industry need to decide what should be left to the legal sort of recourse and what should be left to the contractual negotiation.
absolutely.
And there are two, school of thoughts that let the guilds, the guild system develop in India for this purpose, and then let it be left to the sort of bargaining power of the guilds, rather than the law defining the commercial aspect. So one is the commercial aspect and second one is the first is the legal aspect and second is the commercial. Yeah. So maybe the law can determine the legal aspect, right? But the commercial aspect should be left to the guilds. Is the thought process typically I see work. So do you both agree to that?
I do.
So I completely agree that wherever law tries to kind of reach into the commercial aspect, it always leads to a lot of confusion and the system always kind of breaks down. We have a lot of examples we have seen otherwise as well, on that lines. So I completely agree. I mean, whatever examples Pooja was also giving was about the guild in US and how they operate and the guild contract standard formats and all those things. But in India, even the royalties and all those things is going through a lot of issues right now, the mandatory royalty sharing and all. And we are now ended up with the Honorable Justice Henlow's judgment and looking at the way forward from there. So
yeah, a separate session on music royalties, but because we were talking about performers here, what gets determined under those will ultimately affect the performers' royalties as well. True. Because of the unique position that we have under Copyright Act.
True. Again, I slightly differ on the performers bit because when you look at performers, any kind of work that is created, it's a literary work, lyrics is the literary work, musical compositions is a musical work, all those things are works that are created, performers are performing that work. So that performance being used in a different manner, yes, absolutely, but if there is a remake or something like that and where a different actor comes and performs the same work that based on the literary work, that would be
absolutely
kind of
not.
a far-fetched.
No, but I think the difficulty that we have is the section 39A. Though this provision is not affected, yeah. So that the way they have just simply just as addition they have just put in the act which 39A, which creates a tremendous interpretational issues. So I think that is one aspect probably also we need to revisit as to what issues get created because section 39A, and because of that how at least for the singers, performers and the others which are working under the direction of somebody else, they should be looked at differently or not. I'm not passing a judgment here, but I'm just putting a question across. So do you both agree that 39A needs to be revisited?
I completely, and there are a couple of other clauses, sections also I would really love the government to take a relook at.
So you could probably, both of you could give your suggestions and they will consider that, the team will consider that for their report, because as I said, after this workshop we will have a report coming out. So you can even give your written recommendations. Yeah. But over to the audience now for quick questions, because we have another one small session which is on a very interesting topic just before the lunch. But yes, over to you.
Yeah, hi, my name is Mandar Deshpande. I am also from the academia. My question is, do you feel that is that chaos starting somewhere there where we are yet to sorry.
Legal definition for what?
A legal definition for maybe artist or performer or recreator, because the one thing which I am feeling in this particular matter is when it comes to all of these discussions about who holds the right and who is who and who is what, in terms of legalities we have to literally define that, oh, this is orange, it looks like this, it has this kind of a shape. Have we reached to that stage yet where we can definitely say, oh, this is the legal definition of artist, this is the legal definition of a screenwriter? Because there is a vast difference when it comes to Oxford Dictionary and Indian Dictionary, and there are multiple different ways of putting these things out. So if that is, if you can put a little bit of light on whether there is a legalized definition to it.
So, if you look at the Copyright Act, there are works which are defined. What
Yeah,
are
that's the problem, I think.
No, so we need to find out. I don't think under a particular law you would be able to take each and every nomenclature and define that. That would be like, that may not be a very useful exercise from a law perspective. If you look at the works, it is the literary work. When you look at literary works, it encompasses anything that is written. Now that can be written by a writer, right? As in writer of a story, writer of a script writer, it can be a screenplay writer. So all of them are writers at the end of the day, and they are creating either literary work or a dramatic work. So as long as they are creating one of those works which are protected under Copyright Act, they all come under that definition of the writer, as in who is a writer or author. I want to call it a writer, the author.
Yeah.
So who is an author is defined, and that author, whoever creates that particular work, gets the protection as the first owner of that work. So that way, I think Copyright Act internationally also we'll have to look at how it works. Internationally also operates in the same manner if you look at it. It's an author who is the first owner and rights holder of that particular work that has been created.
And I think what we go back to is how much can the law define something, and how much do you want it to constrict someone from being able to function, right? When you say author, it's actually pretty clear. Literary work is pretty clear from a law perspective. It's for us to interpret it, and it gives you that little canvas to play within. If you tend to constrict it this much, then it may be very difficult, and then at every point you don't have that room for interpretation and have to go to court. So maybe this little openness helps from the perspective of the industry as well, unless you have a specific example as to when this has happened and why you would require it. Of course, there are some instances where there's lack of clarity, but broadly it's pretty clear today on these aspects of it, at least.
Okay, no, I mean, see, a lot of the times in this particular industry, there are multiple types of writers. There is an author of a story, then there is a screenplay writer, and there is a dialogue writer. There are many writers associated with one concept or one theme play. And eventually, because it's art, everyone says that either it will be based on Ramayana or it will be based on Mahabharata. So there is a different author to that as well. So what we are doing is obviously the expression is something which we are trying to cover under this.
So I think you're broadly talking, as Gigi also correctly said, is more from a writer's perspective, and what are the different forms of writers, as you're saying, as the one who actually made the remake, or you made the original work. So I think that goes back to the fact of, and again a little bit of interpretation, because then it gets grey when there is a writer who's written the screenplay, but there's an additional writer who's come and fixed that screenplay, and then there's a dialogue writer who's further gone ahead and written it. A lot of this is industry parlance and goes back to somewhere the concern only arises in two places, right? One is when you have to be given the due credit for it, or when the royalty is also attached to the credit aspect of it, and the second is commercialization, or what needs to be paid. And somewhere the second part of it is a factor of negotiation, and the industry bodies can help. And the first part of it also somewhere we see SWA step in internationally. We do see this clarity given in the WGA's arbitration mechanism, and clarity of credits as to who does what. So goes back to the first part we were discussing, is maybe the law is there, but the industry bodies need to probably, the guilds need to probably help in clarifying it in the event of a confusion.
Okay.
No, I think the question, as you rightly said, will come down to two things: credit, which is contractually maybe parties can agree, but the moment, and there is still debate whether the script writers should be given royalty or not. So that debate I'm not going to get into, but the moment if that is recognized, then the question will be who amongst them, because all have contributed to that, who amongst them. And then whether it will be determined again by inter se contracts or otherwise, right? So that is where we will need to still wait and watch this space because it's still a grey area on that. In fact, my first mentor on IP, very well known Professor Daruwala, he used to always say that copyright is, among all the IP laws, copyright is the most abstruse law. So on that note, probably we can end this conversation unless there is another question, but
Yeah.
we will be quickly moving on to the next session, which is on the NFTs, which is a new upcoming area. Yes.
Dialogue writers and all that. Suppose the film is based on drama, adapted. Drama has certain dialogues. Or even mythology films of Gita's dialogue. They are become as such as they existed. Then who will hold the copyright and what is the other?
So you are talking about drama like Bhagavad Gita, Ramayana and all.
No, all drama. Even social dramas converted to film, for example.
So it's an
There are dialogues. Is there another peak of in the film also? Then how the right will be decided?
So the question here, there are two questions I'll have to ask to respond to this. First of all, are this drama, social drama, which is part of folklore and all those things that you're referring to?
And book also. Drama as
And books, which are modern ones or the early ones, old ones. So why I'm asking these questions is to understand whether we are talking about things which are come into public domain by effects of time. Then obviously it's in public domain. Anyone can create on it. But if you are looking at drama that is contemporary and it is written currently and it's a play, basically that's what we are referring to, then it is a clear adaptation. It's a change of format. If the adaptation from play to a cinematograph film. So comes under the definition of adaptation under the Copyright Act. And for that purpose, let's say we as a studio is going to adapt a play into a cinematograph film, we'll have to approach the writer who is the author of that play and obtain the rights for the adaptation to the cinematograph film. So this has been done actually when in my earlier organization we had approached a lot of playwrights and taken rights to create a cinematograph film out of, as in the playwright, the drama which is on stage, which is recorded and made into recorded plays. So there were two distinct rights in this one, wherein the playwright continued to exercise his right to perform the drama on stage, wherein the recording of that and the cinematograph, the creation of the cinematograph film and performing or communicating that to public on our platforms was exclusively given to us. So this becomes two distinct these things two distinct rights. Did I answer your question?
Yeah.
Thank you.
There is the original dialogue writer in the drama.
Yeah,
Does he have some rights in the same
of course.
dialogue?
Of course, he will have. He's the author of those dialogues. So that is part of the literary works, and yeah.
Yes.
One question to you. So how do you deal with, see you have these lot of cartoon characters which kids like, with all those YouTube shorts and Instagram where kids are made to say these dialogues in say 15 seconds or 10 seconds. So how do you deal with that?
So again, we come back to fair usage and not fair usage, I would say incidental usage there. So it depends on how it competes with our rights and our monetization of the rights. If it doesn't compete directly with our monetization of the rights, then we consider it as an incidental usage, and we just move forward from there. So that's one part we did not discuss about is the incidental usage, which also comes under the legal doctrine called de minimis non curat lex. Basically, law does not deal with trifles or trivial matters. So there is a lot of jurisprudence on this particular point of law as well, and I think Dr. Saraf mentioned about it, as in the exact 5 words which is used in a particular, let's say for example in a program, 5 words of a song has been used in a program, that may come under de minimis usage. But those 5 words, exactly the 5 words, if it is used as a tagline of an advertisement commercial, that may not come under a de minimis usage, because it basically, otherwise the owner would have to be paid for the usage of those 5 words. So similarly in our case also, where if it is a kid using for one small part of it or one dialogue out of it, it is not exactly competing with what we are doing. But let's say there is a complete part of our soundtrack being used as the background of that video, then it would be competing with what we normally exploit or sell. So that's where we would get into an infringement claim or something like that, or a copyright strike on YouTube.
Thank you. So I think unless you have any sort of closing remarks, we'll close this session, but quickly move on to the next one. Is it okay if we continue for say 10-15 minutes? We'll just maybe, Anil, you want to share on the NFTs. We had done quick fireside chat on NFTs. If you have time, then we could quickly move on to the next session, sir, with your permission. Okay. Thank you, Pooja, for your time. Yes.
I would now request Dr. W.N. Dumane to kindly facilitate Mrs. Pooja Kaparia, Head of Business and Legal Affairs, Tulsia Media Private Limited, with a sapling and memento as a token of our appreciation.
Thank you, Pooja.
So again, I would request you to also facilitate Mr. Anil Lale, General Counsel, Viacom 18, who is a lawyer by profession and postgraduate in media laws from National Academy of Legal Studies and Research.
Thought as a part of this discussion, though not strictly on Copyright Act, but it is linked to Copyright Act, is the discussion on NFTs. And Anil, I know since you have handled recently a NFT transaction, we thought maybe a good idea, since we are going to have industry members here, and of course some people are joining online as well, so for the students also it will be very interesting to understand what is this NFT in the and of course people may have sort of traded into NFTs from the audience, but what in essence is NFT, we will discuss that, and then we will come to the rights as to how we look at from a Copyright Act at NFTs, and also what are the benefits that the creative community can derive through the NFTs.
Sure.
So maybe these three points we will quickly take. So the first one, if you sort of quickly explain what we mean by NFTs in the context, in relation to an artistic work or a literary work or say a video clip, because there can be NFTs with respect to multiple other assets, but let's just focus on the copyrighted assets.
Yeah. So when we say NFT, as you all know, the word means non-fungible tokens. It is just a way of attributing a sense of ownership to a particular digital asset. So it is based on blockchain, where once a record is created, you cannot change it. So when it comes into the entertainment domain or the artistic domain, that means any kind of artistic work or clips from a cinematograph film, sound recordings, all these things can be created into an NFT. For example, we have now MTV NFT is called Fully Faltu, which basically is not that faltu, but in which ways, it's basically images that has been curated and created to be minted into NFTs. So the whole landscape of NFT actually will become more and more important when we go ahead, because it's all about digital collectibles. Earlier we used to see that basketball or not baseball, basketball cards in US and all, that could be collected. It used to form as collectibles, and but the genuinity of that particular card was always suspect. Now as a digital asset, the same card, you don't have to have a problem, because on blockchain, the ownership or the verification by an NBA or all those things would be available on the ledger, on the records. So that's how the NFT comes into the artistic domain or the copyright domain, where artistic works can be minted into NFTs. And with advent of metaverse and all, even today in gaming and all those things, NFTs are created using gaming collectibles, like your characters or what the characters wear, the the shoes that they wear, the dresses that they wear, all those things are becoming more and more NFTs, because you can, even after the game is played, you can retain that as a collectible, and the value of the collectible changes according to the demand of the collectible and the scarcity or the availability of the collectible. So that is where generally when we talk about NFT in artistic domain, generally that is what's happening today.
Thanks for simplifying it, because many people still get confused what exactly is an NFT, and you very simply have put it as a collectible.
Exactly.
Because ultimately it's a bragging right that you're having, that I have this, these NFTs are scarce, and I have that ownership. And just to clarify, the ownership of an NFT in relation to a video clip does not mean I own a copyright in the video clip. I'm simply owning a signed version probably of that video clip, right? So there is always that confusion am I owning, can I do anything with that video clip? And then of course depends on the smart contracts. So when you're talking about, you mentioned about say a video clip NFT. Now suppose a talent which is appearing in that NFT, say Shah Rukh Khan is appearing in that particular video clip, and you're creating an NFT. If Shah Rukh Khan was supposed to sort of get some kind of benefit of each sale of that NFT in the market, is that possible, and how can that happen?
So I think it depends on the contract that the artist will have with the particular creator of the cinematograph film, because cinematograph film per se is a work defined under Copyright Act, and if the cinematograph film, when you see it on the movie halls or the screens, it is just the cinematograph film that you're seeing, but the pyramid of rights that is behind that cinematograph film, the restrictions, the rights restrictions, holdbacks, all those things are a complete, it's a web. So when you enter into an artist, especially like a Shah Rukh Khan or someone, he would obviously reserve his personality rights, as in the usage of his personality rights can only be for the purpose of the cinematograph film to be shown in or exploited in certain manners, and he may put some holdbacks regarding clips being used, or if the clips are being used for merchandising. Otherwise, an image of Shah Rukh Khan, just because he has acted in one of the films, can be used on t-shirts, right? So that basically goes into the domain of personality usage. So all those things comes under the contracts which we enter into with the artist and are normally reserved by the artist, and where we need to take it for certain purposes like merchandising or NFT. Sometimes there are premiums that we take out when the movie is releasing. If the character is in a specific form, like for example, in an actor who has acted as Wolverine in X-Men. So in that format of Wolverine, or in that character, the NFT may reside with the studio or whoever has to take it out in that particular format. But as a normal person, as a normal actor, the NFT may still reside with the actor. But again, it all boils down to the contracts and not exactly on copyright or any other rights as far as the artist is concerned.
Right. So I think even the way the smart contracts are written, we understand that if a performer or any singer or whoever has contractually agreed with the producer that every exploitation I will get X percentage.
Yeah,
so because it's a blockchain based phenomenon, it can actually be written in a smart contract so that every sale automatically remits that much money to all the stakeholders who have those basic rights. So
only problem is that it will have to be cryptocurrency then.
Yes.
Otherwise automatically it won't.
So I think that is the other thing, when we look at copyright now, we can't look at in isolation, because a lot of these things that are developing in terms of monetization over the internet or the web or Web 3 that we will get into metaverse, lot of things will get attached to the cryptocurrency or digital currency as a whole. And therefore, if at all some of these new models have to flourish, we will also need to see that it can't flourish unless you have access to these other digital aspects. So
assets as well.
Yeah. So your recommendation seems that you should also consider how do we sort of give validity to, and stability to cryptocurrency in the country.
I don't know how, that's a big
Yeah. No, the point is because the NFTs from an artist perspective, it's going to be very beneficial because it will disintermediate, all the copyright societies or otherwise, if you really see, at least in the digital scheme of things. So can you just visualize that if a talent wants to sort of capitalize on the copyrighted material that it has created, how do you visualize that the right, all these rights can be, right holders can be given their, fair share on, at least on the digital exploitation?
No, as you rightly pointed out, Gauri, the best way to do that would be through smart contracts, and I think that's the way the future is going to be paved. Where, the smart contracts, wherever there is a right that is being exploited, or even today there are royalty collection societies which are formed. They are supposed to distribute revenues downwards, but there is no even uniform database of a music cue sheet system in India today, and we don't have a capability of reporting any of the music usage today to even a copyright society, because we don't get music cue sheets. Even labels who keep music cue sheets, they keep it in different formats, so an AI based system is not even able to understand when we have a music used in one of our programs. Why I'm giving this example is because we are in this space and we are talking about smart contracts, where we are looking at blockchain, we are looking at smart contracts built through blockchain, we are looking at each and every transaction happening through that smart contracts, where the smart contracts recognizes that this transaction has happened and executes a payment that goes automatically to the artist, performer, or whoever it is. So, even a copyright collection society kind of society may not be required if all these things functions properly. As in, it can just execute and say that, okay, this music has been played 100 times on this particular OTT platform. This is the pool of money which is supposed to be the royalty. This goes to this 10 artists, because these 10 artists' songs are the ones which are played the most. Vis-a-vis today, no one understands whose music has played where and how much it has been played for. So I don't even know how the royalty system is actually and practically working on ground, even if the societies are able to collect royalties.
Well, that's a very, very, valid point. And, so because lot of conversation was, in the morning was about how technology is creating, lot of issues in addition to benefits. But I can see this can be a clear benefit where we can deploy technology for, the entire artistic community, or rather all the stakeholders, including the producers. One last question is on the mode and medium concept under the Copyright Act. And how do you look at the digital exploitation, especially in the context of NFTs, and whether the way the law currently reads on modes and mediums, just with this NFT example itself, whether it's something we should take forward, or we should revisit the concept of modes and mediums assignment?
So thank you so much for asking this question, Gauri, because this is one of those things that I was referring to earlier, where I hope the government takes a relook at. So one thing that I found very strange is that modes, mediums, and formats under the first proviso to section 18(1) says that if on assignment of a copyright, if there is a mode, medium, or format which was not in existence or commercial use at that point of time, then the assignment doesn't apply to it unless and until it is specifically mentioned in that contract of assignment. Now today, let's leave today, because today you will say that I'm talking about the future. Let's talk about the past, how it has worked out today, till today. Let's say this law was passed at the time of VHF cassettes. The cassettes, I think some of you may not have seen it also, but the cassettes which we used to watch movies on TVs, right? So those cassettes at that point of time, let's say I'm a producer, I went and took the home video rights, and this law was there. Let's take that for an example. I got the home video rights. CDs, DVDs, Blu-rays were not invented back then. I get the rights. Tomorrow CDs comes, VHF goes out of the window, but I still have home video rights. Does that mean the full term of copyright for that particular right that was granted to me is now extinguished? Whatever I paid for is gone. Because why? There is a new mode of exploitation. So that is gone, new thing has come in, and I don't have a right. If I have to get the right, I have to go back to the owner, take that right specifically. And DVD goes, CD goes, DVD came, DVD goes, Blu-ray came. So all these things are actually replacing technology. And today we are looking at multiverse, right? Metaverse. And we are at the age of OTT platforms reigning everywhere. tomorrow the same OTT platform may cease to exist in a 2D format. Everyone will be watching the same thing on a metaverse on a virtual reality format. That doesn't mean that all the rights that we have taken based on internet, based on 2D format on internet, completely gets extinguished. So if that is the case, most of the OTT platforms would go out of business. So this is something, I mean, again, NFT is a new thing that is coming in. So till today, what was being sold as pictures, image rights that we have taken, NFT was not part of it, or digital image rights if I had, and just because an NFT gets attached to it, does it get extinguish my digital image rights that I paid for? So all these questions need to be answered, and this particular proviso to section 18(1) needs to be relooked. Otherwise, it really and directly impacts the commercial exploitation of people who are investing in this industry, which is not an encouraging factor for people who are looking at future investments.
I think it's an excellent issue. I mean, the way you have put it across, because when the law probably was looking at modes and mediums, they were contemplating that additional will come in, not replace. The moment you are replacing, the earlier right holder loses value, right? So if it is replacing something, then you can't say that, you know, that these are additional rights where the, you know, the underlying rights owner should benefit. And most of the technological advancements will be replacement. It's very rarely that you will have two things working in parallel, right? So I think that is one other aspect I would recommend that DPIIT cell notes is with this specific example that Anil has given. It will make life easier if it is like a bundle of full rights, and then it's a matter of commercial negotiation between the parties. So leave it at commercial negotiation, and we say, okay, any mode and medium gets attached, then you get an additional royalty, or otherwise that's a commercial discussion. But there is no question mark on the right. Right? That is where the ownership.
It just goes to the base of the whole concept of ownership. That's the
absolutely. So yes.
But there is a bigger NFT option open visibly during FIFA. In last 4 days, 100 hours, over $30 billion of NFT origination rights have been signed on paper. How many will actually happen, one doesn't know, because all the countries who have lost the game may not be interested. But at least 4 or 5 top ones will emerge. And like in India also, not to talk of FIFA, Gavaskar and few players have already engaged into NFT. Like there are few other non-media entities. I am saying sports is another kind of thing. Then there is a knowledge NFT also. So why are you limiting your viewpoint to this? And I can only tell you that I was the first general manager in Walt Disney in '93, and Walt Disney left India in '94 because there was no IPR protection in India, and went to WIPO to learn. And I was the first Indian to have attended WIPO in Switzerland. But the truth is that with half knowledge and with partial understanding, we should not encourage into the deal. I think our honorable speaker mentioned about convergence legislation. I am the co-author of that from ASSOCHAM. I was chairing ASSOCHAM Media and Entertainment Committee. I also did the IT Act in 2000 with them. But the whole idea is that even during a parliamentary subcommittee session for IT Act and IT Act modification in 2007 or 8, people were unable to understand what is called cyber. So for them, cyber is like a word from Khyber. I mean, it is a joke, but not like that. But the issue is that how cyber or how future technologies like quantum computer, every protection system in cyber today will be broken in less than 1 second by a quantum. So I'm not talking, but let's talk of little bit larger perspective of NFT. Thank you.
Thank you, sir. So appreciate the large experience and wide experience that you possess. I was talking only about entertainment industries because of the title that we were only referring to in this. Yeah. So that is why we were. No, I completely agree and understand and acknowledge the fact that NFT is not just limited to entertainment industry. It has a lot of wide usage, and more than that, NFT relating to artistic works was the theme of the conversation. But apart from that, NFT actually is going to be useful. I mean, I really hope that this comes into play is where land records are also NFT. So if today, if you have to go and buy a land, you have to go and check 30 years of mutation records. If it is NFT, you just have to do it. You can get the whole verification diligence done in one click. I'm sure a lot of lawyers will lose a lot of money with that, but still, that would be a great thing to see. If you start talking about that, there is an ocean of stuff, futuristic things that we can see what NFTs can do in metaverse. For example, each and most of the stuff will be working on NFTs and AI and all those things. So that conversation, me and Gauri have had this kind of conversation, and it just goes on, and it's hard to limit it in the 15 minutes we are having right now. Thank you.
Thank you, Anil, for your time on this. And with that, I call the session to close the first half, and we will resume for music, and that is going to be more engaging in so far as the complexity are concerned. This was still easy. Music is
I'm glad I'm not part of that.
Neither am I. So that is going to be more complex to figure out, and we have very interesting panel members. And of course, the last one is on piracy and copyright infringement, where we are going to have somebody from the law enforcement joining as well. So stay tuned, and we'll be back.